All right, let's spend a few minutes talking about the meaning of intent. That makes sense since we're starting with the intentional tort. And here's a definition for you. A person acts with intent to cause a particular consequence when she acts for the purpose of causing that consequence, or knowing that the consequence is substantially certain to result from the act even if it was not her purpose to cause it. Now let's break that down a little bit and make a few basic points that I want to make sure you understand. A person acts with intent to cause a particular consequence. Our focus is on whether or not the consequence was intended. We're not so much concerned with whether the defendant acted intentionally. The defendant almost always acted intentionally, and it's almost always completely obvious that he did. I'm going to talk some more about it later on another video. For now, I just want to focus your attention on the fact that the issue is whether the consequences were intended, not whether the act was intentional. The paradigm case, if you will, is when a person acts for the purpose of causing a particular consequence. Now, if I throw a ball at your head and for the purpose of hitting you in the head, whether I hit you or not, we can say that when I threw the ball, it was my intent to hit you in the head because that was my purpose in acting. I wanted it. I desired it. I hoped it would happen. I wanted to bring it about. I meant to hit you in the head. So there's our paradigm case of intent, when somebody acts for the purpose of causing a certain consequence. The law will treat a person as having intended to cause a particular consequence, even if it wasn't their purpose, when they acted knowing to a substantial certainty that the consequence, whatever we're talking about, would result from their act. And there's an old example that's always used to illustrate this. A terrorist intends to kill the king, and he prepares a bomb, and here comes the king and the queen in the carriage as they're passing by, and the terrorist, wanting to kill the king, tosses the bomb into the carriage, and not only the king but the queen is killed. The question is, did he intend to kill the queen? Now let's suppose that he testifies truthfully that no, that was not his purpose to kill the queen. In fact, he thought very highly of her and would, if he could have avoided it, would not have brought her any harm. But the opportunity having presented itself, he had to make the most of it, and so he tossed his bomb. Well, if we assume that he's testifying truthfully, you cannot say that it was his purpose to kill the queen, but we would treat him as having intended it anyway, because when he tossed the bomb into the carriage, he knew to a substantial certainty that the queen would also be killed. The second portion of this definition, knowing that the consequence is substantially certain to result, is fairly rarely applied. There are not many cases in which that we will see, Lyon Brian Daly to the contrary notwithstanding, where a court says that the defendant, although it was not his purpose, the defendant knew the consequence was substantially certain to result from his act. More on that later, but we just want to make that point now. Now let's test this a little bit. Here is our definition of intent and a couple of hypotheticals. A lifts his gun to his shoulder and pulls the trigger, and as a result, B is struck with a bullet. In order for B to show that A intentionally shot him, what will he have to prove? Well, B has got to show that when A pulled the trigger, it was his purpose to shoot B. Or, if it wasn't his purpose, that he knew to a substantial certainty that B would be shot. All right? He's either got to show that it was B's purpose to shoot him, or that B knew to a substantial certainty that B would be shot. Second hypothetical, A is driving along on I-40 when a dog runs out in front of his car. In order to avoid hitting the dog, A pulls his steering wheel to the left, his car goes off the road, and he strikes B. Can the injuries to B be said to have been intentionally caused under the law of torts? Well, driving a car is an intentional act, but that's not the issue. The question is whether or not B's injuries have been intentionally caused. Well, did B act for the purpose of causing them? Probably not on these facts. Did he act knowing to a substantial certainty that they would result? I doubt it. There's nothing in here that indicates that A saw B or anything like that, so probably not. A's driving along. We cannot say that when he swerves to avoid a dog, goes off the road, and injures B, that he intended to cause those injuries.